Last week, Justin Baldoni and the Wayfarer parties filed a motion for judgment on the pleadings in their case against Blake Lively. They're asking for judgment solely on the pleadings, so if you accept all factual allegations in Blake's pleadings as true, the Wayfarer parties are entitled to a judgment as a matter of law. This is different than a motion for summary judgment because that depends on evidence that's developed during discovery. Blake Lively has now addressed this with a short response. She's basically asking for this to either be dismissed without prejudice, for these things to be raised in a motion for summary judgment later on or at trial, or she would like an extension of time to respond to this. So that was a poor choice of wording. This isn't actually a response to the motion, it's a letter to the judge. All right, here's what they had to say. Blake Lively respectfully requests that the court deny the Wayfarer defendant's motion for judgment on the pleadings as untimely without prejudice to the Wayfarer defendants raising the arguments therein in a motion for summary judgment or at trial. In the alternative, Ms. Lively respectfully moves for an extension of time to and including October 27th, in which to respond to the Wayfarer defendant's motion. To be clear, Ms. Lively is prepared to respond to each of the Wayfarer defendant's arguments at the appropriate time, whether that be at the summary judgment stage or at trial. But the Wayfarer defendant's decision to sit on these supposedly meritorious arguments for nearly 9 months means that briefing and adjudicating them now would only lead to duplicative briefing and waste judicial resources, and would force Ms. Lively and the court to bear the burden of the Wayfarer defendant's delay. So basically, why did you wait so long to do this? Tellingly, although each of the Wayfarer defendants' arguments has been available to them since the outset of the case, and although their counsel alluded to the possibility of a motion for judgment on the pleadings on the record at the conference held on July 30th, the Wayfarer defendants waited to file their motion until the response deadline would fall on the last day for depositions in this case, knowing full well that, because of their own discovery deficiencies, Ms. Lively's counsel would be preparing for and taking the depositions of 4 of the defendants during that period. So here's what I don't understand. We have these deadlines, right? And then people complain about each side doing things that are like close to the deadline. I'm like, okay, but it's still before the deadline. Do I think she could be given an extension here? Yes, but it just seems kind of whiny to me. Meanwhile, by the time the Wayfarer defendant's motion is fully briefed, the deadline for summary judgment motions will be only days away, meaning that each of the fact-bound challenges to the pleadings raised in the motion will be overtaken by the record evidence at the summary judgment stage. The question at this stage of the case is not what the pleadings allege, but what the evidence shows, and the appropriate means of answering that question is through a motion for summary judgment. I don't know about that. It kind of seems like she's talking about 2 different things here. Meanwhile, to the extent the motion raises purely legal issues that would not be affected by the summary judgment evidence, the Wayfarer defendants will suffer no prejudice from a few weeks' additional delay in briefing those issues. Ms. Lively filed her second amended complaint on July 30th. Once again, each of the Wayfarer defendants filed answers, this time on August 13th. So that was a little over a month ago. Fact discovery is scheduled to conclude on September 30th, that would be today, with a few exceptions, including a handful of fact depositions to be completed by October 10th, and the production of additional documents withheld on privilege grounds. Expert discovery is scheduled to conclude on November 14th. Meanwhile, the current deadline for summary judgment motions is November 5th. Trial remains scheduled to begin on March 9th. Federal Rule of Civil Procedure 12C provides that a party may move for judgment on the pleadings after the pleadings are closed, but early enough not to delay trial. So as long as it's early enough not to delay the trial and it doesn't cause prejudice to Blake. Whether a Rule 12C motion is timely is within the sound discretion of the judge. If a party engages in excessive delay before moving under Rule 12C, the district court may refuse to hear the motion on the ground that its consideration will delay or interfere with the commencement of the trial. Okay, I'm not sure that's the case though. Like, why would this interfere with the commencement of the trial? That's what I'm not understanding. I kind of get what they're saying as to like this would make things very difficult for her because she has those depositions to conduct. I mean, I'm not going to pull out my tiny violin for her. I think her behavior's been abhorrent, so I don't really care about that. Life's hard, get a helmet. It's not like Blake suddenly doesn't have enough attorneys working for her. Basically, what we're looking at here is like we're trying to make Blake's life easier, which seems to be the goal most of the time here. When they're talking to the Wayfarer parties, it's, well, deal with it, you knew the schedule, blah, blah, blah. When they're talking about Blake, it's like, well, how dare you do this to Miss Lively? She is such a special, precious snowflake. We will be holding a press conference this afternoon to discuss how humble she is. I know we're not done reading here, but I did text Omar, and he said by this logic, he should wait on ruling on 47.1 as well, which is what she was whining about last night. I want my money now. That motion was literally written by Veruca Salt. This isn't the chocolate factory, bitch. It's a court. Now go sit down. Anyways, moving on. Consideration of the motion may still be appropriate if, unlike here, it seems clear that the motion may effectively dispose of the case on the pleadings, but if the pleadings do not resolve all of the factual issues in the case, Proceeding with discovery and potentially a trial on the merits would be more appropriate than an attempt at resolution of the case on a Rule 12c motion. I mean, I don't really see the point with going forward with all of that if those things fail as a matter of law. But again, I'm not a lawyer, so I'm going to kind of withhold judgment on that. Courts are unwilling to grant a judgment under Rule 12c unless it is clear that the merits of the controversy can be fairly and fully decided in this summary manner. The Wayfarer defendant's motion is untimely, although all of the arguments raised have been available to the Wayfarer defendants since the initial complaint was filed. They did not raise them until September 26th. Measured against this court's stated goal of managing this case to a March 9th trial date, that delay was excessive under Rule 12c. Again, from a non-legal perspective, I just feel like this is weak. I don't understand. Why is that going to, cause an issue with the trial date at this point? The deadlines for motion of summary judgment and all of that, they're still the deadlines for motion of summary judgment. I don't understand what the point is here. This doesn't change any deadlines unless she gets the extension that she's asking for, which I assume she will if it goes that route. The motion primarily raises fact-bound challenges to the sufficiency of the SAC's allegations. Those arguments are meritless, but as far as the timing of the motion is concerned, they are more importantly all but moot. At this stage of discovery, Ms. Lively has uncovered voluminous evidence relevant to all of her claims. Okay, but this is not about your discovery evidence, right? It's actually just about the claims that you made in your pleadings. Rather than merely defend the sufficiency of the allegations, to respond adequately to the motion, Ms. Lively would also need to make a proffer of the new and more detailed facts in her possession that would entitle her to amend her complaint should any of the Wayfarer defendants' arguments prove successful as to any of the SAC's claims. Well, she doesn't know that she's going to have the opportunity to amend. What if some of those claims get dismissed with prejudice? The court would then need to evaluate that evidence under Rule 15's futility standard, under Rule 12b-6's plausibility standard, construing that evidence in Ms. Lively's favor along with the benefit of reasonable inferences therefrom. But crucially, that would be the same analysis as at the summary judgment stage when, if the Wayfarer defendants chose to move against any of Ms. Lively's claims or defenses, she would then need to point to record evidence that, construed in her favor and drawing reasonable inferences therefrom, I don't know if reasonable is a word I would use to describe anything adjacent to Blake Lively, but would support a reasonable jury's finding in her favor. Yo, good luck with that. Considerations of judicial economy and common sense, and the goal of holding to a March 2025 trial date, it's 2026. March 2026, guys. Support conducting that exercise only once. For similar reasons, the First Circuit has observed that the legal standard that would apply to the motion and to any request to amend based on discovery is by its nature a threshold inquiry, and logic strongly suggests that it occur prior to discovery. At this stage of proceedings, after substantial pretrial discovery has taken place, ignoring the facts developed during discovery makes little sense. The Wayfarer defendant's motion thus seeks a duplicative exercise that can only have the effect of causing delay. Yeah, I'm having a really hard time taking that argument seriously, given what we read last night and in her initial 47.1 motion. This lady's trying to get the judge to address now things that should definitely be addressed later on, in my opinion. So just reading these things back to back to back, I'm having a hard time finding any sympathy with any of this. Meanwhile, the Wayfarer defendants will suffer no prejudice from having their present motion evaluated on the basis of the summary judgment evidence rather than the SAC's allegations. I don't know about that. They have not sought to stay discovery or otherwise suggested that anything about the case schedule should change based on the filing of their motion. No, and you would freak out if they did. This would be like somebody having a crash out on you and then later saying, well, you didn't tell me to calm down. Yeah, how do you think that would have gone? By contrast, Ms. Lively will suffer significant prejudice from having to file what is effectively an opposition to summary judgment while discovery is still ongoing. This is not a motion for summary judgment, so no. Indeed, the only practical difference between the process for resolving this motion and a summary judgment motion filed at the appropriate time is that, to respond to this motion, Ms. Lively will have to scramble to amass evidence from a discovery process that is and will be generating new evidence virtually every day between now and the response deadline, including depositions of Baldoni, Heath, Wayfarer, Sarowitz, Nathan, and Wallace, not to mention the expert discovery process that will still be ongoing for several weeks afterwards. Again, I'm just not really sure what this all has to do with judgments as a matter of law. I don't know. We'll have to wait and see what the law tubers say on that one. Here's the problem, and it's been an ongoing problem this entire time. It's that I don't know when they're just being stupid or when I'm kind of confused because I'm not a lawyer. The court should accordingly deny the motion without prejudice to renewal of the arguments raised therein at a later stage, or exercise its discretion to hold the motion in abeyance until trial. In the alternative, Ms. Lively respectfully requests that her deadline to respond to the motion be extended to and including October 27th, 3 days after the deadline to exchange expert rebuttal reports. Again, not sure why you would need that, but okay. Unless extended, the current response deadline is October 10th, This is Miss Lively's first request for an extension of this deadline. Miss Lively states that the Wayfarer defendants opposed the extension but did not provide any reason. Okay, sucks. For the reasons given above, even if the court is inclined to permit full briefing of this motion in the final days of discovery, such an extension would be warranted. Look, man, like I said, I don't really understand what a lot of what she's saying here has to do with judgments as a matter of law. Also, the deadlines are the deadlines, and she's got a week and a half, so... But do I think she'll get an extension? Yeah, I do. I think she'll get the extension. Let's see what some of the lawyers who are following along with this have to say about it, and we'll go from there. That's all I got for now, guys. We'll wait and see what the judge says as well. I guess that probably won't take too long. Thanks for watching, and I'll see you all soon.